Good afternoon, and thank you for joining us today for our fourth and final webinar in this series, 5 years at the PTAB, at the intersection of the PTAB and the courts, parallel patent challenges. Allow me to introduce our speakers. Don Banawit is a director in our litigation practice group. He has successfully represented clients across a wide variety of industries and patent infringement actions and has litigated trademark and copyright disputes. Mr. Banawit also has extensive experience in post-grant proceedings before the United States Patent and Trademark Office. He is a contributing author of the firm's Patent Office Litigation Treatise, published by Thomson Reuters Westlaw, as well as the patentability challenges at the U.S. Patent and Trademark Office chapter of the Patent Litigation Strategies Handbook, published by Bloomberg BNA. Mr. Banawit is also a member of the steering committee for the Sedona Conference Working Group 9 on patent damages and remedies and Working Group 10 on patent litigation best practices, and is chapter editor for the Sedona Conference commentary on patent litigation best practices, parallel U.S. PTO proceedings. Jonathan Tuminaro is a director in the firm's litigation and electronics groups and focuses on patent litigation. He has a unique combination of legal and technical expertise with a PhD in physics and over 10 years of experience handling patent matters. He regularly litigates cases at the International Trade Commission, the U.S. District Courts, and the Patent Trials and Appeals Board. Dr. Tuminaro's approach to patent litigation follows Albert Einstein's words, "If you can't explain it simply, you don't understand it well enough." In each engagement, he works to understand even the smallest of details to craft compelling stories that inform and persuade both judges and juries. Dr. Tuminaro has been named a DC Super Lawyers Rising Star in IP litigation for the years 2015 through 2017. And with that, I will turn it over to our speakers.
Thank you. Thank you. This is Don. Today, Jonathan and I are going to focus on parallel proceedings at the Patent Trial and Appeal Board. We'll talk more about the statistics for those proceedings over the past 5 years. Challenges at the Patent Trial and Appeal Board that we'll talk about today have been available for just over 5 years. So we're going to quickly go through some stats first, and then we'll hit on a couple of key areas that affect the interface between district court proceedings and the PTAB. Those are stays and estoppels. And we'll conclude with some thoughts on follow-on petitions, that being serially filed petitions at the Patent Trial and Appeal Board. So just a quick background on what we mean by parallel proceedings. The American Events Act, that was enacted back on September 16, 2011, created a number of new proceedings for challenging validity of patents after issuance at the Patent Office. The most important of those were the Inter-Parties Review, IPR, Covered Business Method Patent Review, CBMs, and Post-Grant Review, PGR. Congress intended for these post-grant proceedings under the AIA to be fast, inexpensive alternatives to validity disputes in district court and the ITC. One way of doing that, the AIA mandates that except in limited situations, these proceedings must be resolved 1 year from institution, which is typically about 18 to 19 months from the filing of a petition for IPR, CBM, or PGR. While these were meant to be alternatives to litigation, there are some significant differences between the proceedings, which are important to consider as we have a discussion today. In district court and the ITC, patent claims are construed according to the P.L.C. framework and are presumed valid. So therefore, accused infringers must provide clear and convincing evidence to establish invalidity. By contrast, in the post-grant proceedings at the PTAB, the board construes claims according to the broadest reasonable interpretation standard, and claims are not entitled to a presumption of validity. So a challenger is required to prove unpatentability only by a preponderance of the evidence. In addition, PTAB proceedings have very narrow discovery as compared to the broad discovery afforded in district courts. As a result, parties in post-grant proceedings must rely heavily on information already at hand and which is obtainable through cross-examination of witnesses. We'll talk about the parallel world today because the vast majority of these post-grant petitions that have been filed to date relate to patents that are concurrently litigated in one or more district court actions or at the ITC. So you get this situation where the same patent is challenged in two forms simultaneously, which certainly has the potential for conflicting results. As you can see from this slide, since these proceedings became available, there's almost 7,000 IPR petitions have been filed, a little over 500 CBM petitions, and PGR, which is only available for patents that were filed after March of 2013, are just now becoming available since those patents are issuing. So their numbers are low and likely will rise as time goes on. As you can see from this chart, it took nearly 18 months for the first 1,000 to be filed, but since then, every 7 to 8 months, about 1,000 petitions have been filed. So it's a really active venue for patent challenges. If we look more on a rolling average, 3-month rolling average basis, you can see there's an average about 150 petitions filed per month. That number was a bit higher in 2015, went down a little bit in 2016, but now 2017 is back on track to be the most active year, almost 160 petitions per month. One other interesting statistic about PTAB filings is if you look at all the petitions that have been filed and divide them by the number of unique patents that were challenged, you get a ratio about 1.6 to 1, which means that there are certainly numerous situations where the same patent is being challenged by multiple petitions. As we'll talk about at the end today, in some cases that's serially, in other cases it's in parallel. A couple interesting statistics to frame our discussion of stays and estoppels today. This slide shows the institution rate of PTAB proceedings. As you likely are aware, once a petition is filed by a challenger at the Patent and Trademark Office, there's a chance for the patent owner to file a preliminary response, and then the board determines whether or not to institute the proceeding. At the beginning of these proceedings, back in 2013, that institution rate was about 90%. As time has gone on, it's started to level off now. We're looking at a rate just above 60% institution. Also, as we'll talk about a little later in our presentation today, the board doesn't always institute on every claim that's presented for challenge by the petitioner, and often doesn't institute on all grounds either. Once the proceeding is instituted, that's what's then called the trial. It's a 12-month proceeding by statute where the patent owner gets a chance to respond to the petition, and then the petitioner gets a reply. There's a hearing before the board, and ultimately the board issues what's called a final written decision. In a final written decision, the board takes up the issue of the patentability of the claims that have been instituted over the grounds that have been instituted. The way we've looked at it with our own internal statistics here, we've looked at all of the claims that have been instituted across all the patents that have been put into a post-grant proceeding where that proceeding has been instituted. Looking at those particular claims, to date, it's about 3/4 of the claims that have been instituted into a proceeding have been found to be not patentable. That number is even greater for CBMs, where over 90% of the instituted claims have been found to be not patentable. This number over time has come down a bit, just like the institution rate. At the beginning of these proceedings, it was pretty high rate of finding of unpatentability. As time has gone on, it's come down a bit, but we're still at a pretty high percentage of claims are found unpatentable in these proceedings, making them a great venue for challengers of patents. The Patent Office also releases statistics on a monthly basis. The Patent Trial and Appeal Board issues these on a monthly basis following the PTAB proceedings. And they have in there, if you take a look at those on their website, every month they have a chart similar to this shown on slide 9 here, where they outline what happens to the various different petitions. The reason I put this up here is that they look at things just a bit differently than we did on the previous slide, where when they compare the final written decisions all the way on the right, what they're looking at is, of all the final written decisions that have issued, in how many of those decisions were all claims found to be unpatentable, some claims found to be unpatentable, or no claims. And by their metric, they found that of all the final written decisions they've issued, in 65% of them, all claims were found unpatentable, and in 16%, some claims were found unpatentable. It's less than 20% of the time do they issue a final written decision where the patent owner is successful in defending all the claims that were challenged in the instituted trial. Two different ways of looking at the same statistics, but at the end of the day, this is still a venue that's very good resource for patent challenges, because most patents have been found to be not patentable, most claims found to be not patentable. We have a totally separate webinar, which you may have attended, on Federal Circuit appeals from these PTAB proceedings. I won't go into too much detail here, but just to frame our discussion of stays and estoppels, many of these final written decisions from the Patent Trial and Appeal Board are being appealed to the Federal Circuit. You can see from this slide the numbers are almost as high as the rate of filings at the Patent Trial and Appeal Board. And this number, which deals with final written decisions, obviously is going to trail somewhat of the number of petitions filed, because you've got to go through the proceeding and get a final written decision. But looking at the outcome of these decisions, at the beginning, the Federal Circuit was affirming quite regularly the Patent Trial and Appeal Board's final written decision. But as time has gone on, the affirmance rate is coming down and the remand rate is going up, where now we've got about 70% affirmance and around 20% remand. Many times the remand is because the Federal Circuit found that the panel at the board didn't adequately lay out the reasonings for the ruling. Those get remanded and the board reissues an opinion with a better explanation. In some other situations, there may be a claim construction issue that the Federal Circuit disagrees with, and that gets sent back down to the board to reevaluate things under a different reading of the claims. But ultimately, this has now caused a question in the final decision, and encourage people who lose a final written decision to go to the Federal Circuit in hopes to get it overturned or at least remanded. With that, we'll go into stays of proceedings in favor of PTAB.
Thanks, Don. This is Jonathan. As Don mentioned earlier, defendants often have several reasons why they might want to file a petition at the PTAB, including a favorable claim construction standard at the PTAB compared to district court, lower standard for proving invalidity, and limited discovery. But one of the driving factors for defendants often is the possibility for getting a stay of a co-pending district court case. So here we have the standard factors that a district court judge will consider when deciding whether to stay a case in view of an AIA proceeding. The first three are familiar to many: whether the stay will unduly prejudice or present a clear tactical disadvantage to the non-moving party, the plaintiff or the patent owner. Often this factor only is a driving motivator in competitor-to-competitor cases. The second factor, which is also familiar, whether a stay will simplify the issues. This is typically the driving factor for most decisions in stay decisions by district court judges. And the third is just the stage of the proceeding in the district court, whether discovery is completed and whether a trial date has been set. So this often counsels for defendants to get their AIA petition at the PTAB early in order to increase the likelihood of getting a stay. The fourth factor there on slide 12 is for CBMs. This is part of the statute, or at least section 18 for the covered business method proceedings. It's whether a stay or the denial will reduce the burden of litigation on the parties and on the court. Parties often thought that this factor was intended to make stays of CBMs more likely than perhaps the other proceedings. On slide 13, we have the stats for district court stays from 2012 to the present. On the top slide there, we have for motions that are stipulated or sua sponte, and the bottom table is for contested motions. I think there's three sections of time periods that are of interest. The first is the time period between 2012 and 2013. If you look at that time period, it seems to be a slight jump or an increase in the likelihood that the court would grant a stay. And one explanation for that could potentially be the transition from the old inter partes reexamination framework. According to that framework, district court judges were often reluctant to stay a district court case in view of an inter partes reexamination because it was unclear how long or when that proceeding at the patent office, the inter partes reexamination, might end. Well, that's changed now with the AIA proceedings because there's this one-year statutory requirement to get the proceeding completed. So that initial jump in district court stays may be associated with the change in the proceedings at the patent office and the district courts becoming comfortable with how those proceedings might play out. Between 2013 and 2016 on these stats, the stats stay roughly flat. For the contested cases, there's about a 63% chance, mid to low 60% chance of getting a stay, and for the contested motions, it hovers around 50%. But in 2017, it seems to be a bit of a change, at least with respect to the contested motions. If you look at 2017, that's the first year that it became, for contested motions, the first year that it became more likely that a stay motion would be denied rather than granted. In 2017, 49% were denied and 43% were granted. One explanation for that potentially could be the handful of estoppel decisions that came out in 2016, which we'll address later in the presentation. But those estoppel decisions made it appear, at least, that the estoppels that were written into the statute weren't as stringent or didn't have as much teeth as many practitioners may have thought. And after that, those decisions, district court judges may have become a little bit more reluctant to grant this a motion to stay if they were still going to have to decide some of the same issues in the case, and the estoppels wouldn't attach. Moving on to slide 14, we've broken out the stays by district, and it's clear here that the Northern District of California is the most likely to grant a stay, whereas in Eastern District of Texas, it's sort of it's almost 50-50 whether a motion will be granted or not. There's the 9 that were partially granted. So this just breaks it down by district, the stays. It's important to sort of understand these statistics and understand what district you're in, whether filing a stay, a motion for a stay might be likely to be granted or not.
Jonathan, what do courts do with these district courts do when they're evaluating stays and you've got multiple parties involved, but not all of those parties, say not all the defendants, are involved in the IPR?
Oftentimes what we've seen is that the district court judge will require will grant the stay only if the remaining defendants who aren't parties to the PTAB proceeding agree to be bound by any estoppels that would attach in that PTAB proceeding. Because the district court judge doesn't want to grant a stay if it's not going to actually reduce the issues.
And that becomes even more troublesome when for the judge evaluating the issue when the IPR has been filed by someone other than the defendants in front of them. You know, maybe it's an indemnifier or it's a party in some other litigation, and the defendants are there before the judge asking for a stay when none of them are involved and none of them will be stopped.
Yeah, and that might be one of the reasons that the district court judge would want to deny that motion for a stay and just keep moving forward with the case. And that might be one explanation for why we're seeing a slight decrease in the likelihood of getting a stay in recent times.
And obviously, you talked about the first factor of being simplification of issues. Obviously, if the patent is found to be unpatentable and nothing comes back to the district court, that has significantly simplified the case. But if the patent owner is successful, is there still a chance for simplification of issues? What might the district court be able to benefit from a final written decision where the patent owner is successful finding their patents patentable?
It could certainly simplify issues. The final written decision, maybe in the district court case, there are multiple patents that have been asserted, and the proceeding at the patent office could potentially reduce the number of patents that would be at issue in the district court case, or the proceeding at the patent office could reduce the number of claims that might be at issue after the final written decision from the PTAB. Some claims may be found patentable and others not, and that could reduce the number of claims that the district court judge would have to deal with in the district court case.
And even though the standards are different, potentially there'll be some discussion by the parties and the board on issues of claim construction or the scope of the prior art or the scope of the patent that could be informative to the court as it then tries to deal with the same patent in the district court proceeding.
It could be informative. I think, at least sort of anecdotally in my own practice, it seemed that courts and parties were more hopeful that those sorts of issues might be resolved in a PTAB proceeding and they could transfer over to the district court case. But as the case law has progressed and there's clearly a different claim construction standard, I think parties and district court judges are all less, they're more reluctant to just rely on an issue by issue basis that claim construction issues might go away based on what happened in the PTAB because of the different standards, different burdens of proof. So I think in recent years, the simplification has to do with really the number of patents and the number of claims and not the number of issues.
And of course, one other challenge for the court it was the same with the re-exams as well. It's very difficult to introduce anything about these proceedings into the case, especially if it's a jury case.
That's right.
Because to tell a jury that this is a patent that went through an IPR and was found to be patentable can be very prejudicial, really sway the jury's decision making. And you'd expect, if somehow the defendants are able to use something from the proceedings to help their invalidity case, there would have to be a balance of that. Well, then we're going to say that you allow the jury to hear that the thing went through. So it does seem from the judges I've heard speak about this, they're very reluctant to allow the IPR to be discussed as part of the district court case.
And that whether the IPR can be discussed in the district court case is also district dependent or judge dependent. We don't have a slide on this, but anecdotally, it seems like Delaware judges would be more likely to preclude parties from talking about what happened in the IPR, whereas judges in the Eastern District of Texas seem more willing to allow parties to talk about what happened in the IPR. So that really does seem to be shaking out as a district by district dependent on whether the IPR can be talked about in the district court
does seem that the judges are waiting in many cases until an institution decision before they're willing to decide on this issue of stay.
That's right.
So it does, I would counsel you to get in your IPR petition as early as you can in the district court litigation so that you can get that stay decision as soon as you can.
That's right. If as a defendant, one of your motivating factors is a stay, you should file that petition early at the PTAB.
Good.
With that, I guess we move on to estoppel, and I'll turn it over to you, Don.
Thank you. So that the AIA included several estoppel provisions that could affect co-pending litigation or subsequent validity challenges. Jonathan had mentioned earlier about the old inter-parties re-examination provisions, which also had estoppel as part of it. But there, the estoppel didn't apply until all appeals were finalized. So that's what actually made those proceedings so long, was that they all were then appealed to the Federal Circuit, and the district courts were wondering, when are we going to ever get a final decision here that the estoppels apply? One thing that was changed with the AIA was to make the estoppels apply on the final written decision of the board. So as we talked about, that's 12 months from institution, probably about just a little over 18 months from the filing of a petition. There's a final written decision, estoppels will apply that affect the district court proceeding. The estoppels are a little bit different depending on which proceeding you're talking about. For the IPR and the PGR proceedings, the estoppel applies to any ground that the petitioner raised or reasonably could have raised during the PTAB proceeding. CBM, on the other hand, the CBM proceedings, the estoppel only applies when we're talking about estoppel at the district court, only applies to grounds that the petitioner raised during the CBM proceeding. If we're talking about the application of the estoppels to subsequent proceedings at the patent office, CBM, IPR, and PGR all are the same estoppel in that case, and it's a raised or reasonably could have raised. But for purposes of the district court, there is a division there for IPR and PGR, raised or reasonably could have raised. For CBM, just what's raised. But the important thing about here, which we'll get into as the Federal Circuit had to deal with this issue, is the statute on estoppels talks about the raised or reasonably could have raised during the IPR proceeding or during the PGR proceeding. So the during the proceeding part was critical to the Federal Circuit's analysis of this in the Shaw decision last year. In Shaw, in just a little background, IPRs, as you may know, proceed in two phases. In the first one, the Patent Office determines whether to institute, and in the second phase, there's a trial and issues a final written decision. So the first question is, should the board institute or not? And there's a rule within the Patent Trial and Appeal Board that allows the board to institute on all or only some of the claims that are presented before it in the petition, and to institute on all or only some of the grounds before it. So in the Shaw case, what happened was the petitioner filed on certain claims on multiple grounds for those claims. The board instituted the proceeding on certain claims, but only instituted as to some of the grounds that were presented, didn't institute as to all grounds presented for that particular claim. So then the question became whether or not the defendant could raise these issues later on in district court proceeding that were not instituted as part of the IPR proceeding. The Federal Circuit looked at it and said, you know, at the end of the day, the grounds that are not instituted for a claim that's instituted are grounds that could not have been brought in the IPR proceeding. That's the second phase, is the way that the Federal Circuit looked at it. They said, well, the IPR proceeding is just the trial. It's the post-institution period. And since the board said, well, we're not going to go forward on those particular grounds under this claim, there was no way for the petitioner to raise or reasonably could raise those grounds in the trial. Therefore, the Federal Circuit said that those weren't grounds that would be estopped, even though those were originally presented as grounds under a claim that was instituted. So it seems like somewhat of a fair decision in that The petitioner never had a chance to argue those particular issues. But then as the district court started to deal with this issue, this Federal Circuit decision was evaluated in diverging ways. There's a decision here that we've got on the slide from the District of Delaware, Intellectual Ventures versus Toshiba, where the Delaware court took up the issue of estoppel, looked at the decision in Shaw, and said, well, it seems to me that the proper application of this reasoning by the Federal Circuit is that the only things that are estopped are those things that were actually brought up in the proceeding. Everything else is something that couldn't have been brought up in the proceeding because it's proceedings limited to just what's in the trial. So not only did this court think that it was appropriate, as the Federal Circuit said, to allow defendant to go forward with grounds that were not instituted for a particular instituted claim, but basically anything that wasn't part of the proceeding. So any grounds that weren't even presented in the petition were fair game, and effectively turning the estoppel into just what was actually raised in the proceeding. Another court that dealt with this in West District, Wisconsin, the Douglas Dynamics decision, looked at Shaw, looked at what the District of Delaware said, and said, well, ultimately that doesn't make sense, that the point of the estoppel and making it one that was raised or reasonably could have raised was not to limit the estoppel simply to those issues that were brought forward. So that the Wisconsin court said, at the end of the day, we're going to split this out, that we agree that until the law is changed, the Federal Circuit decision is such that if there's a claim instituted, but not on all grounds, those grounds that were not instituted for that claim are eligible to be argued later on. Estoppel does not apply. But for everything else, the estoppel applies. And that, in the Wisconsin court's view, was the fair way to look at this thing. We've got up here as well, the Patent Office has dealt with this issue. One example is this Great West Casualty case, where they also looked, the board also looked at it as the Western District of Wisconsin did, and said, look, the estoppel doesn't apply to grounds for instituted claims where those grounds weren't themselves instituted. But everything else the estoppel should apply to, we have to look at, raised or reasonably could have raised. At least for now, we've got a division. I think the majority of district courts and the PTAB are on the side of a narrow, what we call the narrow view of Shaw, which is a broad estoppel. And the Delaware case is somewhat of an outlier right now in that, but at least suggests that there are some out there who would say there's the decision in Shaw should be broadly applied, and the estoppels from these proceedings are very narrow. The confusion over this, for one, has created an issue with respect to stays, because now district courts aren't really sure what's going to come back to them. But it's also created an issue when these cases actually do come back, of the parties fighting over what grounds are still available. When it might have been the case that the court thought that validity wasn't even on the table when the case comes back to it. Now the parties are saying, not only is it on the table, but we've got to look at, there might be certain arguments that are similar to those ones that were raised at the board that are still available to be argued at the district court. We'll see if this gets clarified some more by the Federal Circuit, or potentially if it's hinted on at all of the cases that are currently before the Supreme Court. But for now, we have some conflict here and some uncertainty. One thing that if you look at the narrow interpretation of Shaw, sort of this broad view, and you're trying to figure out now, okay, well, the estoppel says it's got to be raised or reasonably could have raised. That then raises the question of, well, how do we determine if something reasonably could have been raised in the proceeding? So some courts have dealt with this now. We've got one example up here from the Northern District of Illinois. But what seems to be a common way for courts to get their hands around this is to evaluate what would a skilled searcher have found? And if you can evaluate, if a skilled searcher was going out there to try to find prior art against a certain patent, what would their search strings have been? What would they look for? And what other criteria would be part of that search? And then you can compare that against whatever reference it is that the party is now saying they couldn't reasonably have found before. This case, they said that the plaintiff had to present evidence on this. This is a case where the plaintiff was trying to get summary judgment that this ground was out, that they couldn't argue invalidity over this part. And ultimately, the court required this testimony from them. There's another case recently where both sides presented different evidence on this issue, and ultimately the district court judge brought in a special master to deal with the issue. Said, well, I got to have some third party, some unconnected to the parties here, evaluate this issue so I can get some understanding of what a skilled searcher would have found. But currently, this is what courts are looking at when they deal with the issue of reasonably could have been raised. And that's where we are currently with the estoppels. We'll move on to the last topic we wanted to discuss here today, follow-on petitions. Jonathan?
Thank you, Don. So follow-on petitions, the real motivating factor here for the PTAB is trying to curb what the PTAB views as the unfair practice of filing serial attacks on a patent owner. So here's a quote from the General Plastics versus Canon case. Multiple staggered petitions challenging the same patent and same claims raise the potential for abuse. The absence of any restrictions on follow-on petitions would allow petitioners the opportunity to strategically stage their prior art and arguments in multiple petitions using our decisions as a roadmap until the ground is found that results in the grant of review. So that where it says that using the PTAB's decision as a roadmap, that's one of the real concerns that the PTAB has, is that its decision or the patent owner's preliminary response might be used as a roadmap to allow these serial attacks on a patent owner. One thing I'll note here is that one of the reasons why this might be perceived as a problem by the patent office is because the statute allows anyone to file an IPR as long as there's no estoppel, but there's no standing requirement to file an IPR. So anyone from the public can file an IPR against any patent. So it creates this possibility where there could be an endless barrage of attacks on a single patent. One thing I'll note is not clear at this point, at least from what we've seen, whether the problem of these follow-on petitions is a widespread problem that affects multiple different patent owners. But there is sort of anecdotal evidence that shows that for at least some patent owners, they've been hit with many petitions on the same patent. So at least for some patent owners, there has been an abusive practice of filing 2, 3, 5, and maybe even 17 in some cases petitions on the same patent. So the board has sort of gone out of its way to address this issue and what it believes is an inequity.
You know, and John, the part of the design of at least the IPR proceedings was that they require the defendant in litigation to file an IPR within a year of service of the complaint. So given that, you would expect that there would be very limited ability for folks to file serial petitions because everything's got to be filed within the first 12 months. But that doesn't always work in these situations, right?
That doesn't always work. I mean, there have been situations where, as we talked about earlier, defendants will want to file their petition early. So shortly after being served, maybe they know about the patent, so they could get their petition in early in that 1-year period, even in time to be able to get either the patent owner preliminary response and maybe even the institution decision from the PTAB before that 1-year time bar period would expire. And there have been instances where the petitioners have used that patent owner preliminary response, or the institution decision as a roadmap for filing a second IPR petition against the same patent within that 1-year time period. So that's a possibility. And also there's a possibility that a potential filer is maybe not served with a complaint. They're on the sidelines, so they don't have a 1-year bar that might start, but that potential petitioner on the sidelines has some interest in the litigation. So they don't have the 1-year time bar, but they could sit back and on the sidelines and watch as an IPR or a PGR might play out, and they could decide after the patent owner preliminary response or after the institution decision whether that sideline petitioner just wants to come in and file their own petition. And the board is sort of recognizing in this general plastic cases, and there's some other earlier cases, that sort of practice, there's the potential, at least the potential for abuse in that sort of practice. So what the board did to try to curb that abuse in this general plastic case is they made it, this case precedential as to these 7 factors, which are now on slide 19. I apologize, this slide has a lot of text on it. It simply lays out the 7 factors that the PTAB now considers in deciding whether to deny a follow-on petition. Now, as I mentioned, these 7 factors were first articulated, I believe, in an NVIDIA case. There are several other earlier cases that have a similar theme, but this general plastic case is a precedential decision now, which means that all other panels have to follow this decision as to the 7 factors to consider when deciding whether to deny or institute a follow-on petition. So just running through these factors, the first one is whether the same petitioner filed a petition directed to the same claims of the same patent. So same petitioner, same claims, same patent. One thing to note here is that this factor and all of these factors in this test are not limited to just a single petitioner. This is sort of the scenario that I was mentioning earlier in response to Don's question is you could have a petitioner on the side who's not even served with a petition, hasn't even filed a petition, but that petitioner on the sideline could be denied institution on a follow-on decision based on the PTAB's discretion under this general plastics case. And Don has an example from the Samsung case you can mention quickly.
Yeah, we don't have the site up here, but I'll give you, there's a decision October 17th in Samsung versus P.L.L.C 3DS Innovations. It's IPR 2017-01305. And in that particular case, the panel in reviewing, in making its institution decision, reviewed these same 7 factors, and at the end of the day concluded that it would exercise its discretion to not institute this follow-on proceeding by Samsung. And as you mentioned, Jonathan, of note there, Samsung was not a previous filer of a petition against the patent involved in this particular proceeding. Now, one thing that was made it maybe slightly different than someone just simply being on the sideline, Samsung was going after a number of patents held by this particular patent owner and was involved in over a dozen IPRs, just not on this particular patent. But the board there, when looking at this first issue, the Samsung argued strongly that this first factor should counsel against the board using its discretion because they weren't a previous party. But ultimately the board looked at it and said, well, you didn't previously file on this, but we think that only minimally weighs against. And as we go through these, I'll maybe address some of the other factors they looked at.
Yeah, okay. So moving on to the second factor, this goes back to whether the petitioner knew or reasonably should have known about the art that it's now trying to file in this follow-on petition. So when analyzing this factor, whether the petitioner, the follow-on petitioner, should have known of the art that it's citing, the board has been relying on this reasonable search criteria, so sort of like what Don was mentioning earlier with respect to the estoppel cases. So that seems like a fruitful ground for dispute going forward, whether a party should have known about a reference. But what the board is often relying on, again, is these search strings or some kind of search strategy to identify the reference. The third factor is this roadmap factor. Did the petitioner have the patent owner's preliminary response or the board's institution decision at the time that it's filing its follow-on petition? The board is really concerned about the follow-on petitioner using these earlier filings as a roadmap for filing a subsequent petition. We're trying to curb that practice. And 4 and 5 sort of address or go along with whether the patent owner or the petitioner knew about those earlier filings or decisions. So factor number 4 is the length of time that elapsed between the time the petitioner learned of the prior art and the second petition and the filing of the second petition. So here, petitioners, any petitioner, even if you don't think you're a follow-on petitioner, petitioners should explain or risk a denial why any length of time between its petition and some earlier filed petition. And one thing that patent owners are often doing with respect to this factor number 4 to try to find any knowledge that the follow-on petitioner knew of the references by looking at district court pleadings, for example, the invalidity contentions in a district court case, or even an entity's filings at the patent office, applications that it might prosecute at the patent office if art was cited against that petitioner or that entity during prosecution of maybe some of its patents. Patent owners are trying to argue that the follow-on petitioner, that's evidence that the follow-on petitioner knew of the reference, and it should be a basis for denying the follow-on petition. And this is where factor number 5 plays in, whether the petitioner provides an adequate explanation for the time elapsed between the filing of the multiple petitions directed to the same claims of the same patent. So here, the follow-on petitioner is given an opportunity to explain itself, essentially, and if the follow-on petitioner doesn't want to get its petition denied, should have a good explanation as to why its petition is essentially different than the earlier petition, and why the institution should be had based on its own petition. Factors 6 and 7 are really they're board-specific facts, the finite resources of the board, and the 1-year time period to get these proceedings completed. These factors 6 and 7, it's interesting, when these proceedings first began, the PTAB, as we saw earlier, the PTAB institution rates were up around 90%. That could be just that the PTAB needed to get a number of these proceedings in its docket to start to lay out a framework for how these proceedings were going to progress. But now that the AIA proceedings have become so wildly popular, factors 6 and 7 here seem to be the board's effort to try to manage its own docket. And I've heard some say that the number of filings at the PTAB are somewhere up to 4 times more than what the PTAB or the PTO was originally expecting for these types of proceedings. Now, one thing I'll note here is that the board, in laying out these 7 factors, the PTAB said that its authority for laying out these 7 factors comes from 35 USC section 314A, and that's the section that provides that the director may not authorize an inter partes review to be instituted unless the director determines that the information presented in the petition shows that there is a reasonable likelihood that the petitioner would prevail with respect to at least one of the claims challenged in the petition. So the PTO is reading this section 314A as its authority to institute on only some claims or some grounds. And the PTO issued its own rule based on that section 314A of the statute. The PTO rule is 37 CFR 42 32.108A. And in that rule, the PTAB says that the board may authorize the review to proceed on all or some of the challenged claims and on all or some of the grounds of unpatentability asserted in each claim. So the PTAB is finding its authority in Section 314A. It's not finding its authority for denying these follow-on petitions based on 325D, which some may be familiar with. 325D says that the board may deny institution if substantially the same art or substantially the same argument is presented to the board. But the PTAB in General Plastics is not relying on 325D. It's relying on Section 314A. And I'll note that although these 7 factors just came out, they might be at issue in a case that's currently pending at the U.S. Supreme Court, and this might go away soon. In SAS Institution, Inc. versus P.L.L.C, that's number 16-969, the SAS, the petitioner, is asserting that if the PTAB institutes, then Section 318A of the statute requires that the PTAB must issue a final written decision as to every challenged claim. So the SAS's position is that the board can't just institute on certain claims and it has to decide the patentability of every claim that's challenged by the petitioner. The PTO's responsive brief says that that's really not the issue that's before the board. The institution decision is not before the board, and the PTO again says it has the authority under 314A to Section 314A to only institute on certain grounds and certain claims, and Section 318 only requires the PTAB to issue a final written decision on the instituted grounds. So we'll see whether the Supreme Court takes up this issue about the PTAB's authority to institute on only some grounds. I'll note that the SAS Institution versus P.L.L.C case is scheduled for oral argument at the Supreme Court on November 27th of this year. So it'll be interesting to watch how or if that decision will have any impact on the PTAB's authority to deny follow-on petitions.
Yeah, and just quickly back on that Samsung case I mentioned about the first factor. Ultimately, the board, the 2 factors that were most important to the board there were 3 and 5 that you have up here. On 3, they found that, in fact, Samsung actually mentioned the POPR and the arguments made by the patent owner in its petition. So they said that, clearly they're using it as a roadmap, and that strongly weighed in favor of using its discretion to deny. On the flip side of that was factor 5, where Samsung argued, well, this particular patent wasn't asserted against them the same time it was the other petitioners. About a year later, it was asserted. And the board said that was a pretty compelling argument weighing against using its discretion. But ultimately, in balancing all these things, and I think part of it was the fact that, like we said, the first factor, Samsung, while not a previous petitioner, was involved in a bunch of filings. They used the discretion, denied the petition under this, the follow-on petition. So something to consider if you're sitting on the sidelines while other people are filing their petitions. Will it be available to you when you've got a chance to file? I think we got a couple of questions as we went along here. One question related to our issue of stays. The question was, well, now that so many of these cases are being appealed to the Federal Circuit, what kind of impact is that having on district court staying? Is that more likely the courts will be less likely to grant a stay, or are they still granting stays as they would, given that I think part of the question there is, well, what do you do during that time frame? You've got your final written decision. Great, that came out 12 months from institution. But now, as we've seen in the stats, it can be a year to a year and a half before the Federal Circuit decides, and then in 20% of the cases, it's being remanded. So how does that factor into the district court analysis? I've heard from some judges look at it that they say, well, look, the initial stay decision is stay in favor of the PTAB proceeding. then they ask the parties to come back and tell them what's going on once a final written decision comes out. And that's where they can kind of reevaluate where things stand. You know, if it turns out that the patent has gone down, you know, probably the district court's going to say, well, all right, let's wait out the Federal Circuit decision. I don't want to spend a lot of time on this patent that's not going to come back to me. But if it's found that the patent's, you know, it's patentable, and while that could be changed by the Federal Circuit, the estoppels apply now, everything should go forward, there's not a whole lot of reason to delay going forward with the case in favor of that Federal Circuit appeal. But I do think that the parties are starting to bring more of this timetable into the initial discussion and say, oh, we're going to be waiting a real long time, we shouldn't be staying.
Yeah, I think that's right. You know, the stats seem to bear that out, that it seems like more now of just a race to the Federal Circuit. The district courts are less willing, less likely to stay. And one thing I'll note, you know, this is about district court proceedings, but at the ITC, there's definitely not going to be a stay at the ITC in view of a PTAB proceeding. They're certainly going to go forward with their investigation in parallel with any PTAB proceeding. And I think that district court judges are coming, some of them are coming more around to that sort of viewpoint, that it's unlikely that there's going to be a lot of simplification of issues. So maybe we're just going to go forward with this case, and whoever gets to the Federal Circuit first, we'll deal with it then.
Yeah, it will be interesting if they start to tail off significantly. Another question we'll just end with here is our thoughts on an explanation for the decrease in institution of these proceedings at the board. Do you have any thoughts on that, Jonathan?
A couple thoughts. Number one, I think parties, when they're asserting patents, are vetting their patents more thoroughly, and they have a better sense of what might survive a PTAB attack. So that could be a potential reason for the lower institution rates. And another reason for the lower institution rates, as I said, could just be about the PTAB trying to manage its own docket. Early on, the PTAB could have been more likely just to let more petitions institute more proceedings in order to sort of build up a critical mass and build up a set of case law on how to deal with these. But now that the proceedings are so popular and the PTAB is so overworked, they're trying to find more ways to limit the number of cases that are actually instituted.
And likely the Federal Circuit decision is probably having effect on it as well. Now that the Federal Circuit is giving some pushback on the way the board is evaluating things, that likely is causing at least some panels to be more critical of the initial petition. That's all the issues we have today. Hopefully that was informative for the group. We appreciate you listening in today. And if there are no further questions, I think that'll be it for today. Thank you very much.
Thank you.